colleagues and I here are not here to give you legal advice. We're here to discuss legal issues that you may wish to take up with your attorney if you're not an attorney. And if you are an attorney, you need to do your own research. Things change regularly in this area of law, as we'll be talking about today. And you need to be responsible for your own legal work. However, what we're talking about today is the procedure by which one appeals from some sort of activity that's taken place in something other than what's called a court, but before an administrative body or other state-related agency or body, and where there's an aggrieved party, and the party that's aggrieved wants to take the decision to the superior court in the county in which the body resides in order to seek judicial review of what happened in the body. The particular case that we're talking about here is a zoning case. However, I've been informed that other administrative bodies that pass on the rights and obligations of citizens, such as alcohol licensing boards and such, also are affected by this law and essentially have to follow the same appellate procedure. We'll be talking about mostly a case that came out from the Georgia Supreme Court in 2017, known as the City of Cummings versus Flowers. Case number S16A 1884 and S16A 1885, also at Georgia Reporter 300 Georgia 820 and 797 Southeast 2nd 846. That case dramatically changed the way in which one appeals from a lower body in some instances, and tried to lay out a across-the-board rule that would then be followed in the future. However, and in so doing, they overruled precedent that had been standing in Georgia, and no doubt in my mind, resulting in many cases being thrown out along the way, or some cases that weren't thrown out surviving. And one of the first things mentioned in this case as a rationale for overruling stare decisis, they say, and this is actually the second point in where they determine whether they can overrule existing precedent. It says, second, the issue is one of appellate procedure, not contract, property, or other substantive rights in which anyone has a significant alliance interest. And if you can remember anything from this Quillian's kernels, also known as litigation fundamentals, appellate procedure wins. If you don't get the appellate procedure right, it doesn't matter anything what to do with your substantive rights. If they throw your case out, you've lost, and you could be totally right in every way, but if they throw your case out, you lose. And so therefore, if you don't know how to appeal what you're trying to appeal, and the court ultimately doesn't agree with how you appealed, it has no bearing on whether you were right or wrong, whether your client's interests were protected or not in the lower body. And I almost, frankly, find it humorous. It goes on to say, we recognize that in this particular case, the homeowners, and we'll talk about who they were, may have sought review of the Board of Zoning Appeals variance decision by mandamus rather than certiorari, based on the precedents like Jackson, the Supreme Court precedent. But there is no indication that many, if any, other pending appeals will be dismissed as a result of the decision today. Well, first of all, who puts in data regarding all the cases that are pending in Georgia to show what will happen if a decision is made that you don't anticipate in the first place based on stare decisis? And second of all, I was with a zoning attorney on the day this case came out. He said he had about 20 cases pending in the Superior Court, all of which he predicted would be completely thrown out because he had followed the Supreme Court precedent in place at the time he filed the appeals. And this case completely threw out this Cummings case completely threw out the plaintiff's case after they had done exactly what the Supreme Court had said they were supposed to do at the time they were supposed to do it. So, so they never had their substantive rights rule on at all, because the case just threw it out. The Supreme Court threw it out, even though they had done exactly what the Supreme Court required them to do at the time they did. So, what is this subject matter? Your client has some matter to be heard before an administrative body. That could be, as mentioned, a town or a county ruling on a zoning issue relating to their real property. For instance, they have a piece of real property. They think it should be able to be used for use A, but the county says they can't use it for that use. So they file something at the county and ask for the opportunity to go ahead and use it for that purpose. The county says no. And so therefore they can't use the property for what they wanted to use it for. And who knows what the reasoning of the county might have been. It might have been because they're actually reading their zoning ordinances and determining that under the past ordinances, that's not an allowed use. Or it might be because their brother-in-law doesn't want the person to use the property close to the brother-in-law's property. At these quasi-judicial places, you don't really know what the influences are that are causing a determination one way or another. Similarly, in those same bodies that make decisions regarding specific pieces of property might also be the ones that actually legislate what the law is going to be associated with property in general within their jurisdiction. And so those same bodies that are sometimes acting as judges often are also, and maybe their principal purpose is, to act as legislative bodies where they actually pass the laws that impact the citizens within their jurisdiction. So you have this entity that does two completely different things. It's not like you have a Georgia legislature and then a set of superior courts. You have, in this instance, let's say a town council that does two completely different things, legislates and also decides cases. So that will ultimately play into an analysis of how you appeal from that entity, depending on what they did at the particular time they did it. Yes.
I imagine you would also have members of the executive branch on that same body. So, for example, perhaps the mayor or some other executive of the municipality would be on that body, or is that?
Yes. So the question is whether this same body that both legislates and makes judicial decisions, are there executives who are part of the jurisdiction also on the body? And the answer is, I think, almost all the time, yes. For instance, the mayor is always on the city council, and depending on what kind of town charter or city charter you have, that mayor has more or less power than they would. Similarly, you might have the zoning administrator somehow directly involved on the council as well. And then usually there are preliminary bodies before it gets to the final body that might be a planning commission or a board of zoning appeals that decides on the issue before it gets to the final decision maker within that administrative setup. But we've got a situation here where those people, as I mentioned, could be are very often non-lawyers. Lots of times my observation is they're told what to do by their lawyers. In other words, they don't even know what decision they're making. They just do what their lawyer tells them to do, which means you really have this third party who's not on the actual body telling the body what to do, and that's very influential on the body. And then also they can come up with whatever decision they want to. And it might be completely right if you were to analyze it like a lawyer, or it might be completely wrong if you were to analyze it like a lawyer. Similarly, they may come up with legislation they don't understand at all that they just sign off on because somebody told them to sign off on it. And then they have to read the legislation that they didn't understand in order to come up with the decisions that they are making with respect to an individual piece of property. So there are all sorts of things that can happen at these administrative bodies. So if you had a client that had a matter that had to be decided before one of these bodies, then we're not going to go into this. But first of all, you got to figure out how do you get your matter before that body. And that's going to be a matter of following procedures and the local ordinances. And also any other state laws that might impact on that. So we're not going to focus on that because you could actually get there a variety of different ways, usually filing an application, paying a fee, having some sort of hearing, etc. What we're going to focus on is once that body has made a decision on whatever it made a decision on, how do you get to a higher judicial body in order to get a conclusion reached? Now, the specific City of Cummings versus Flowers case, what happened there was up in Cumming, Georgia, this townhome developer had built some townhomes and they were already constructed, and they were completely not in compliance with the zoning for this town or city. I guess it's the City of Cumming. And like some of them were much closer to the street than they were supposed to be. Others were still under construction and they were further back because the developer had gotten the memo, so to speak, along the way. And so the question was, what do you do with the condos that are still there, that are almost completed? What about the ones that are half completed? And so they went to the town and they asked for a variance saying, please let us leave the ones that are there and we'll construct the rest of them in accordance with the zoning. And basically the City of Cumming said, okay, tear down this one, you can leave these other ones that are not in compliance and then build the rest in compliance, something along those lines. And there were some homeowners who didn't like that outcome, and so they wanted to get to the higher court to overrule what had been decided. And they argued, or they thought in their minds, at least at the time, that this might have been a legislative decision that was made by the city because the city determined that it was going to do something completely different from what the law said it was going to do. In other words, it's passed a law. It says this is the law. You have to be 20 feet away from the road, but the townhomes were 5 feet from the road, so therefore it had to legislate to make that change. But on the flip side, you could say, well, they just looked at the facts and they decided what they were going to do on the facts, and they applied their own law, and that's the way it ended up. They were either right or they were wrong, but they looked at the facts, they made a decision regarding those facts, and they issued a ruling. So they were acting like a judge in that scenario. And the Supreme Court would say, yes, they were acting like a judge. They were just acting like a terrible judge. So the homeowners wanted to attack this. Well, there was a case called Jackson, which is cited in the materials I circulated. Well, we'll just call it the Jackson case. Jackson versus Spalding County, 265 Georgia 792, a 1995 case, which said what you do in this scenario is you look at the ordinance that's been passed by the town and see whether it says, the town or the city or the county, whatever it is, and see whether it says there's an appellate procedure. And if it says within it that you're supposed to file a petition for certiorari to the Superior Court in order to appeal from the decisions of the city, then you do a petition for certiorari. And if it doesn't say that, you're supposed to bring what's called a mandamus action. And a mandamus action is a different form of action in Superior Court where you're trying to get the Superior Court to tell the administrative body what they have to do, as opposed to just relying on what legislative administrative body has decided to do. And but on the flip side, if there is a petition for certiorari mentioned, you do it that way. If not, you do mandamus. There's a later case that came out called Harlson versus Taylor Junkyard, and that case is 291 Georgia 321, 2012, that says, wait a minute, you can't, a town or city can't legislate what the appellate procedure is for getting jurisdiction in the superior courts of Georgia. So if if certiorari is allowed, then it has to be by certiorari if that's the appropriate procedure. And if certiorari is not allowed, then you don't have to follow the procedure set forth in the local ordinance. So that would be in situations where there are a lot of cases I think were thrown out along the way where the town ordinance said certiorari, but the person filed a declaratory judgment action, and then the superior court would throw it out because the town said it was supposed to be by certiorari, even though the appellate procedure was maybe just a legislative decision that had been made by the administrative body, and a declaratory judgment action was perfectly appropriate. So once you read this Cummings case, you'll see there are whole lines of Supreme Court cases that they've just completely struck and said, these are all, we had this, this, and this, it was inconsistent with this, this, and this. And so it was a total nightmare to try to figure out why they were just drawing these distinctions. And if you applied these various rules, how did your case fit into that rule? So the Jackson case said, if the town says you have to do it by certiorari, or the city says, then you have to do it that way. And what the Supreme Court decided was, hey, this is crazy. We've got people bringing cases coming out of quasi-judicial bodies in every which way, depending on what the ordinance says from which the person is appealing. And that the ordinance should not have anything to do with it. Even if it says what it says, it doesn't have any ability to put a case in superior court one way or another. And people are doing it different ways for the same thing, depending on where they are. And so that puts lawyers and other people in jeopardy about how do you do it right? Because if you do it wrong, as I said, appellate procedure rules, you get thrown out. And so we're just going to do, we're going to overrule Jackson, and we're going to wipe out all those cases that relied on Jackson, and we're going to implement a specific rule that's already provided by Georgia statute, which is OCGA 541. And what that says is, in subsection A, the writ of certiorari shall lie for the correction of errors committed by an inferior judiciary or any person exercising judicial powers, including the judge of the probate court, except in cases touching the probate of wills, granted letters of testamentary and of administration. So that's a very broad appellate statute and long-standing in Georgia that says the writ of certiorari shall lie. And so fundamentally, then you've got to somebody's got to make a determination as to whether what the administrative body did was exercising judicial powers, or whether they were inferior judiciary. And so I think a lot of people were thinking, gee, what is the town council really an inferior judiciary? Or is it another person exercising judicial powers? And the Supreme Court comes up with a test in Cummings that says this is how you figure out whether it's judicial, whether it's a judicial action or whether it's a legislative action. Basically, the legislative is somewhat clear. If the power, if the council or the administrative body is making a rule that applies to everybody, and you're not focused on any individual person's rights, and you're doing it sort of across the board, like rezoning the entire town, passing a whole new zoning ordinance, that would be an example of a legislative act. But if somebody comes before them with an application and says, I want to fix this problem relating to this property, and they have to look at facts associated with that individual instance, and if they have to apply an existing ordinance to that specific piece of property or what historically has happened with those people, then that's acting in a quasi-judicial role. So what we're focusing on today is quasi-judicial role exercised by administrative body. As you can see, though, it's sometimes wishy-washy as to what actually happened and what role they were taking. So it's possible, and I might even recommend it in some circumstances, that if you have circumstances where an administrative body has made some decision, you might have to file two different lawsuits. One, a declaratory judgment action, and then secondly, a petition for certiorari, because what if somebody decides just the opposite, like happened in this case down the road? You lose your rights. All right, so what is a petition for certiorari? First of all, keep in mind it's got to be done 30 days after the ruling that you're appealing from, which means if the town mayor signs the thing, gives it to the clerk mails it in 3 days to the people involved, you're only likely to have 20 days by the time you learn what happened. It is a situation where you, as the litigant, the complaining litigant, you have to go to the superior court and ask the superior court judge to affirm your right to ask the clerk, to tell the clerk to send a writ to the body below, telling them to send up all their records on what they did in the administrative role. But before you can do that, you have to get the administrative body to certify that you paid all the costs associated with what you did in the administrative body. So it's a very laborious procedure. You got 30 days to get it totally, finally filed in the superior court. So basically, you better move the second you get an adverse ruling in from the administrative body. Because the time is going to start not when you get the ruling, it's going to start whenever they enter it on their own books and records. And as I said, I don't think they're sending it to you overnight courier. I think they're going to be sending it to you snail mail. So the City of Cummings case versus Flowers said from now on, all such appeals will be done by certiorari. And they overruled all the wishy-washy back and forth, if this and that, and if that and this cases that happened over the last 20 years. And so first thing you would do if you had such a ruling is you would have to go get a certification from the body that issued the opinion saying, I paid all costs to date for that proceeding. And then you have to go over, you write up a petition, which would be your complaint regarding everything that happened wrong in the lower proceeding. And as I think I threw out in my email, we could enter into a debate as to what the appellate review being provided by the superior court would be. But as far as everything I can tell, you sure as better heck have tried everything before the administrative body. And you better be prepared to have some evidence of what all was tendered, what the facts were at the time, you know, some sort of record of what happened, a recording or whatever of the proceeding, because it looks to me like you're going to be limited to the record that you created before the administrative body. Yeah.
In the areas where I practice, that's an interesting quandrum that you have. So the scope of review of a probate court decision, right? Probate is part of the judicial branch. The scope of review is not limited to the record. So it's trial de novo in the Superior Court. The other tribunal.
Now, about what county? Because it depends on which county you're in. The probate courts, there are two different types of probate courts.
Right.
In Georgia, there's the one for the big counties and there's the one for the little counties.
So the scope of review varies based upon what county you're in?
I don't know. I know the scope of the trial. I think in a big county, you don't go to the Superior Court after the probate court, or you go straight to the Court of Appeals.
I think you always go to Superior Court.
Okay, so.
But what I find interesting is that's a judicial tribunal, and yet you try your case there, and then if you appeal it to the Superior Court, you try your case over again. The other tribunal in which I practice is the Georgia Tax Tribunal, which is a arm of the executive branch. They call it tribunal, but it reports up through the executive branch. But in the Georgia Tax Tribunal, you must establish a record, because appealing that decision to the Superior Court, the scope of review is limited to the record.
Mm-hmm.
So here you have a executive branch where you have to create a tribunal where you have to create a record, and a judicial branch tribunal where if you don't create a record, you get a trial de novo anyway. Makes no sense, but that's what happens in those two tribunals.
Okay, and if we were to repeat the general rule of this session is appellate practice wins, right? So unfortunately, you have to take into account every factor that they could possibly pull a rug out from under you with as far as the appellate practice goes. And note that before the administrative bodies, you don't have any rights to discovery or anything else. So I don't know how you could possibly present all the factors that might come into play before an administrative body, because frankly, there's a lot of cover up. And I mean, I hate to say this, but like in the case I had, we found out that by subpoenaing the town attorney's computer, that he had not drafted the ordinance that was adopted 2 weeks earlier until 2 weeks after it was adopted. Yeah, it was signed back then. So, yes, things like that. How would you ever learn that? Because they're just up there with the papers nestled close to their body or whatever they have, and they'll say they had what they didn't have, such as that, in order to avoid facts and litigation. So you got to get this certificate of some genre. I actually tried to get sample forms from a friend, and I think I will get them, but I don't have them now. The certificate of paid costs from the entity that you're appealing from. Of course, that person might go on vacation immediately upon issuing the bad judgment, which could be a problem. Then you got to take your petition over to the Superior Court judge. The statute doesn't actually say, this is OCGA 543. It just says the appropriate judge, I believe. It doesn't actually say which judge is the one you're supposed to be taking it to, but it has to be, I think, based in context, the Superior Court judge. You take your petition and you have to take a bond over, saying, no, I paid the costs below. I'm issuing a bond saying I will pay all the costs in the appellate proceeding. I believe it's limited to costs. They actually refer to it as an award. You will pay whatever award is entered in the appellate proceeding. And, you know, it making the attorney sign up for paying the award. The alternative is that you can get a pauper's affidavit, but I don't think we're going to be representing very many people on these appeals under a pauper's affidavit. One way or another, the judge then has to determine whether your bond is sufficient for the petition for certiorari or whether the affidavit is sufficient. If you have either the affidavit or a bond, the judge can say, I don't like your bond, I don't think you're good for whatever the award is going to be. You have to swear what your assets are in order to get me to sign off on this bond for you to do your petition for certiorari. So there's a provision in there for doing that. But let's assume for the moment the judge says, okay, I'll take your bond that you will be paying the award resulting from this appellate procedure, and the judge signs off on that bond that you have provided. Then you take it to the clerk, and if you have all those papers, the cost thing from below, the bond from above, the certification by the judge, then the clerk is mandated to serve, I think within 5 days, your petition for writ of certiorari upon the appropriate designated body, and direct those people to send up the records from what happened at the administrative body. After all that is accomplished, you were then and they send it up, you were then in Superior Court to do whatever it is specifically that's allowed to be done at a case subsequent to a petition for certiorari, which presumably, if it was the denial of let's say a denial of a building permit, assuming that is a quasi-judicial action and not a purely administrative action, then it could result in the Superior Court judge saying there was absolutely no reason for this city to deny its building permit, therefore I order the city to issue the building permit. And we had mentioned in earlier litigation fundamentals with Henry Quillian that if you get to the point where you get a judgment by the Superior Court, then there's a question of what sort of appellate rights do you have from there. And the Shoemaker case, which we had mentioned earlier, Shoemaker versus City of Roswell, which is 2017 Lexus 554, decided June 30th, 2017, held that if the whatever it was decided by the administrative body was purely legislative, then you would have a direct right of appeal to the appropriate body. But if it's quasi-judicial, you have to do an application for discretionary appeal. So we've got a situation here where if you have your rights affected by an administrative body and you want to fight for your rights, you've got to get past the Superior Court judge deciding whether they're going to allow an appeal. Then you got to have the Superior Court judge decide the appeal. It may or may not be the same one. Then you got to have an application for discretionary appeal to the appropriate appellate court. I think this whole setup looks to me like a big effort for this appellate courts to whitewash and get rid of a lot of cases so that you never have to take cases of this type. That's my sort of general thought.
And just based on this City of Cummings case, is the procedure any more clear?
Sorry?
Is the procedure any more clear based on this case?
The procedure is very clear, and the clearness is that it's very onerous because you have to follow this procedure for a writ petition of certiorari. A couple of things to worry about with respect to this is it's very interesting. This is pretty old statutes, and it's something you can think about depending on who you're representing, whether you're representing the administrative body or whether you're representing the person complaining. Is it says there's actually something in there that says the answer cannot be written or dictated. The answer to the petition for certiorari cannot be written or dictated by anybody that had anything to do with the lower proceeding. And apparently, if let's say it's the same lawyer that represented the administrative body at their initial hearing, if they sign the answer to the petition for certiorari, you can have that answer stricken because it's invalidated under this statute, which I found to be real interesting. And the parent, like a 1912 case or something like that, the theory there is that anybody that had anything to do with it, what happened below is probably tainted somehow, so they shouldn't be signing answers regarding what happened in the lower proceeding, in the appellate proceeding. And what I take from that, however, is that it looks like your petition actually has to lay out all the facts of what happened and the petition itself, and the answers and either the denials or admissions, more or less lay out the record for the Superior Court in the appeal. That's the way I'm reading it, because they're saying whatever the lawyer is that, or the person that drafts the answer, is ultimately totally important to the outcome of the appeal. Looks to be like they're saying that becomes the record, the petition and the answer. And then whatever is litigated, I guess, over what was denied. If we were to sort of sum up, what we need to worry about here from a practical standpoint is, if you're doing one of these things, one, think about whether you need to get somebody as a super specialist in whatever thing is happening, whatever administrative procedure you're doing, because it's going to be hairy from a appellate standpoint. And you got to decide what all you're going to present in the lower venue. Secondly, you have to go through all the administrative procedures that are available under the lower venues or rules, unless they're overruled by some Supreme Court case that you better find, because, like I said, you can't follow exactly what it says in the ordinance, because those are sometimes preempted by the state law. And next, second upon getting an adverse ruling, you better put on your running shoes and get stuff prepared, and all these basic signatures from all these people really quickly, because the mayor goes on vacation and you never can get that certification that you paid all the costs below, right? So therefore you can't go to the Superior Court judge to get your petition filed within 30 days. And then you've got an absolute deadline. If it's late, then everything just stops. Whatever decision of the lower administrative body was made, that sticks, and you won't be going any further in your case. Also, you need to be prepared to swear out your affidavit. Maybe you need to take all your financial statements and brokerage statements to the Superior Court so you can swear your affidavit saying you have adequate money to pay the cost of the award in the Superior Court. That sounds crazy, but that is what the statute says. And then make sure that the clerk does in fact issue the writ and that it's served within 5 days, because that's a requirement as well. Any other thoughts? Has anybody ever, other than Julian, had a situation where you had to determine whether the record below controlled everything that happened above when you're coming out of something other than a trial court? Randy, what's
unemployment compensation hearings, those sorts of things, or Department of Labor hearings? The record that gets appealed is the record that's developed below. You can't bring in other stuff later on.
Okay, so it's not clear to me what's picking up on this microphone with respect to this thing. So Randy says it's unemployment compensation hearings and
Other Department of Labor hearings.
Department of Labor hearings. So you always got to know when you're going in to advocate for somebody, you have to create the entire record, or can you just make your argument? Have you ever been to some of these hearings, like a zoning hearing or a variance? You might be given a minute and a half, something like that. So you better talk fast, and you better have lots of stuff to hand them. Lots of times, however, there is no clerk or anything to keep a record. So like the mention here is in the Shoemaker case, experienced zoning attorney read his letter regarding the unconstitutionality of the ordinance into the record, because there was no other way of getting it into the record. There's no clerk's office to give it to, so to speak. So, any other thoughts?
Well, I guess what occurred to me when you talked about these what extent are these procedural dismissals considered res judicata or restart the litigation by making a subsequent application on the lower body, so that even though you got thrown out procedurally, sort of start over?
So the question is basically, can you go, if you got kicked out of court because of this problem, not following appellate procedure correctly, is it res judicata as to the rights of the underlying property? And I think that would depend on whether something changed. This is just not pure thought, whether something changed in between. Like maybe if you had a new potential buyer for your property who wanted to use it for a particular purpose, because otherwise your property would be perpetually, let's say the law said you have the right to have general building contractors in your space, but the person who wants to be the general contractor applies and gets rejected by the town, and then you try to appeal that, but you do it wrong. But the law still says you have the right to use it. If you get thrown out of court because you didn't do the right appellate procedure, or you're forever barred from having general contractors in your, I would say that you would need to start all over again and reapply. And David seems to think that might be the case.
Most of these zoning laws have a limit on how many times you can submit something, and it's limited by how many days there are between each application. Like you can't apply again for 90 days or something like that. Most of them have that in it. So you may have to wait, but and I would certainly make some substantial change in the application just to be careful. But that just means you can apply 4 times a year.
Okay, so David Forstner says, and I do recall actually seeing this in zoning ordinances I've seen, is that most of them have limitations on the number of times you can apply for any particular remedy. Usually it's a time limitation, like every 90 days or no more than 2 in a year or something like that. So you're going to have some holdback and just try to start all over again. The other thing that does happen is administration has changed. And there's no stare decisis among a town council. A new town council can decide completely opposite of what the one that preceded did. So it might be worth to make a change, especially if you got kicked out of court because of a procedural error, or a procedural in error that then was found years later to be an error before you got any remedy. Yes.
Every week, we discussed the scope of review being limited to the administrative record. What about the standard of review? Is the standard of review always the same, regardless of what you are appealing to the Superior Court?
The question is the standard of review versus the scope of review the same? We talked about, it's a little uncertain as to what the scope of review and whether it's limited to the record. But is the standard review, for instance, is it de novo or is it abuse of discretion? I know on these mandamus actions, the people assert that it's abuse of discretion or completely arbitrary ruling by the lower body. And so I think it depends on if it's purely a legislative action and you're filing a deck action, which is something different, then that would be de novo. Was the action constitutional or not? But it may well be an abuse of discretion standard if it's something like the denial of an ordinance or completely arbitrary. That's what I've seen mentioned. It may depend on what sort of proceeding is being appealed from. In other words, I suppose you could have a variety of outcomes depending on what you're asking for in the first place as an administrative body. And this seems to be such a broad rule, it could be any type of decision that's made below that is then looked at above. In the Shoemaker case, after the people went all the way through, they only asked for a determination by the Superior Court in a deck action that there was no due process in the passage of the zoning ordinances, and that's because the advertisement for the zoning ordinance said specifically, no property rights will be changed by this zoning ordinance. That was the advertisement in the newspaper. And they got there and they totally changed, apparently, according to the plaintiffs, the property rights of the people in the town. The town decided, the shoemakers decided to only appeal the constitutionality of that passage of that ordinance. So they went to the Superior Court. It threw the case out, saying it should have been by a different mechanism. They then appealed to the Court of Appeals. The Court of Appeals said it's a discretionary appeal because it's a zoning case. And that's everything that was a zoning case had before Shoemaker, it was determined if it involved zoning at all, it had to be a discretionary appeal. The Court of Appeals threw it out. The Supreme Court took it on certiorari. The Supreme Court said, no, it's purely a legislative decision. So therefore, it didn't have to be by application for a discretionary appeal. So therefore, the direct appeal to the Court of Appeals was good. So then they remanded it back to the Court of Appeals, and the Court of Appeals held, oh, you could have resolved this whole thing down by complaining again at the city, telling them to applying to them to reissue an advertisement of the zoning ordinance so that you could then have another hearing on whether it was properly presented to the town. I don't even know how you get to that point, but they said there was a remedy for these people to cause the town to basically re-legislate the zoning ordinance. And so the Court of Appeals dismissed the case. So this is not an area you lightly trudge into because very often there's no remedy provided, I guess, to your client. It's just a lot of litigation over a lot of mumbo jumbo, and the courts seem to fancy themselves and trying to make it as complicated as possible. So, any other thoughts? We will wrap it up. Thank you for being here. Come back next month for Litigation Fundamentals with Henry Quillian.